International law distinguished from municipal law. It has already been noted that international law differs from municipal law because the former regulates interstate relations and the latter intrastate relations. However, this factor on its own does not tell us enough about the substantive differences between the two types of law and the elements that make international law unique. The articulation of the fundamental differences between the two types of law is essential for a proper understanding of the nature and process of international law. International law differs from municipal law in terms of the law-making process, the basis of obligation, the system of enforcement, and its interplay with the international political process. The characteristic features of Australian municipal law, and indeed any country's municipal law, are the existence of a recognized legislative body, a hierarchy of courts with compulsory jurisdiction to settle disputes over the law, and a binding system of enforcing the law. Unlike municipal law, international law has no legislature. Even the General Assembly of United Nations, which has representatives from all member states, is no legislature, and in any case, its resolutions are not legally binding. Municipal law is hierarchical or vertical, with the law-making sovereign, such as Parliament, in a position of supremacy, enacting binding legislation. On the other hand, international law is horizontal, with all states being sovereign and theoretically equal. Sovereign states themselves create the law that is used to regulate the relationship between them. This is very much unlike the case in municipal law, where the individuals is in subordinate position to the sovereign making the laws, may only choose to obey or disobey the law, but do not make the law, at least not directly. States create international law by concluding agreements accepted as binding on each other, and by their established practices, which they accept and recognize as legally binding. One aspect of the horizontal character of international law is that there is no international police force to oversee obedience to the law. In addition to this, where there are breaches of the law, international law has no established compulsory judicial system for the settlement of disputes or coercive penal system in the sense that we know it in municipal law. This is not to say that there are no judicial or quasi-judicial tribunals in international law. This is not to say that there are no judicial or quasi-judicial tribunals in international law. The International Court of Justice, ICJ, is a vital part of the international legal system. However, unlike the case in municipal law, no state can be compelled to appear before the court or any other tribunal in any proceeding. There have, of course, been instances in which the international community has used coercive action to enforce international law. In the 1991 Gulf crisis, for instance, when Iraq invaded and occupied Kuwait, the UN authorized the use of force to expel Iraq from Kuwait. Again, during the siege of Sarajevo in Bosnian conflict, the UN accepted a bombing campaign against the Bosnian Serbs as part of its strategy to break the siege and facilitate a negotiated settlement. Despite these cases, the enforcement of international law is principally non-coercive. The instance in which coercion has been used are more exceptions than the norm. Much more important, not only in the use of coercion in such case considerably circumscribed, but like many other aspects of international law, it is influenced to a large degree by political consideration.